Taxi boss Joe Ferrari Sibanyoni is a free man. Yes, you heard me right. After spending some nights in jail, he's going straight home today. That's because a courtroom meant to decide the future of this high-profile criminal case became the stage for one of the most unexpected legal collapses in recent memory.
How do you feel?
Well, I was always positive about today's matter, but all the same, everything is all right.
By the end of the day, the accused did not walk out in handcuffs. They walked out free. And it wasn't because of a verdict on the allegations. It was because the state never showed up to court. What followed was a legal breakdown inside the Kwaggafontein Magistrate's Court that led to the extortion and money laundering case against taxi businessman Joe Ferrari Sibanyoni and all three co-accused being struck off the roll entirely. A case involving millions of rands, claims of intimidation and alleged criminal networks paused, then derailed in a matter of hours, and in the middle of it all, accusations of contempt, courtroom frustration, and a magistrate who eventually made a decision that stunned all those in attendance. But how did a case this serious collapse so quickly? And what really happened inside that courtroom? Well, let's talk about what we do know. At the center of the matter is taxi boss Joe Ferrari, widely known as Joe Sibanyoni, along with three co-accused. It's alleged that the allegations come from between 2022 and 2025. The state alleged that these payments were extracted under pressure and threats tied to business operations. All four accused have consistently denied wrongdoing, with each of them arguing that the matter stems from business disagreements, unpaid invoices, and disputed commercial arrangements. But none of those arguments would be tested in detail on this day because the trial never progressed. The case simply vanished.
And I'm inclined, therefore, as I do now, strike the matter off the roll in terms of Section 342A, subsection 3C.
Mr. Court, please.
LC, please, the court direction.
Court is adjourned.
Court was scheduled to begin at 9 a.m. and a prior directive had made it clear all parties were required to be present. But as the hours passed, something unusual became clear. The state prosecutor was not in court, not delayed, not excused, simply not there. Inside the courtroom, tension began to build as defense teams, accused persons, and court officials waited with no clear update. The delay stretched on for nearly 3 hours, and what began as a routine procedural morning slowly turned into a legal crisis. Representing the accused was former National Director of Public Prosecutions, Shaun Abrahams, instructed by attorney Mpumalanga. What he presented to the court was not just frustration, it was a direct challenge to the conduct of the state. He argued that the prosecutor had ignored a clear court directive. He further raised concerns that the state's conduct was undermining the authority of the court itself.
I'm instructed to move an application multi-pronged. The first is to find the learned prosecutor, Mr. Ntaba, in contempt of court. The second is to request and implore on your worship to strike this matter from the roll. Alternatively, should your worship be so minded, a bail application being an inquiry of the court for your worship to grant the accused bail.
And according to submissions made in court, the defense raised three major applications. First, that the prosecutor be held in contempt of court. Second, that the entire case be struck off the roll due to the state's failure to proceed properly. And third, if the court rejected those arguments, that bail should be considered. The tone inside the courtroom shifted immediately.
Now, your worship would appreciate that the presumption of innocence which my client and his co-accused presently enjoy is a hallowed principle lying at the very heart of criminal justice. Now, that presumption of innocence protects their fundamental liberty and human dignity. And not only theirs, but every other person accused by the state of criminal conduct.
This was no longer just about extortion allegations. It had become a constitutional argument about respect for the justice system itself. Abrahams told the court that orders are binding and must be respected by all parties, including the state itself. He argued that ignoring such orders weakens the entire justice system. At one point, he described the situation as one where judicial authority risks becoming meaningless if instructions from the bench are not followed. He further requested that the court take strong action, including possible sanctions against the prosecutor, and that the matter be referred to disciplinary authorities such as the Legal Practice Council and the National Director of Public Prosecutions.
Your Worship, I'm saying the reason why you should treat this matter as an unopposed bail application is that the state, at the closure of the applicant's case in respect of accused number 2 and number 3, the state indicated that it will be opposing the bail application. And the court made it clear to say they ordered, one, the investigating officer, Mr. Ndebele, to be here at 9, and 2, the prosecutor to be here. The main purpose of that order was simple, that the state must be afforded an opportunity to provide reasons why it is opposing bail. They are not here.
So, according to the defense, the failure to appear was not just a scheduling issue. It represented a deeper breakdown in procedural responsibility. As time passed, frustration inside the courtroom became increasingly visible. The magistrate noted that despite the direct order, the prosecutor still had not arrived.
I did receive a report. It would have been just before 9 o'clock that he had phoned the control prosecutor here in Kwaggafontein to say that he was in transit, that he was held up by paperwork, and no time or even an approximate time for his arrival was given.
At one point, the court was informed that the prosecutor had been in transit, but no clear time of arrival was given. By the early afternoon, the court's patience had run out.
So, my lady, I am a bit disturbed because the mother in me feels that I don't know whether I should make legal submissions or I should mother somebody else who deliberately disrespects a court. First, my lady, let me start by saying the following. Our instructions are purely that we should ask for a contempt. And I will demonstrate to this court why. Because the integrity of our judicial system rests heavily on the shoulders of prosecutors.
The magistrate then made the critical finding. The magistrate said the conduct amounted to contempt of court. A warrant of arrest was authorized, and in an even more consequential decision, the magistrate ruled that the matter be struck off the roll, and that decision changed everything.
The conduct of Mr. Ndaba has left my mind boggled. I saw him for the first time at the last appearance on Friday. And there was a point at which I indicated that he was being unprofessional. And today, sadly, we still have to sit with that. I gave a clear order addressing him directly that it is the court's order, Mr. Ndaba, that you be here at 9 o'clock on Monday, the 18th of May.
So what do you think? Should a case this serious be struck off the roll just because the state failed to appear? Let me know your thoughts on that in the comments section. And remember to subscribe to the channel. Also hit that notification bell so that you know when I go live or when I load a video. With the ruling delivered, the extortion and money laundering case against Sibanyoni and his co-accused effectively came to an immediate end. The legal process did not proceed to bail arguments or evidence. It stopped entirely.
I think it is only reasonable for this court to find him guilty in his absence of contempt of court. And I will authorize a warrant for his arrest. Also, the court will report his conduct to the LPC and to his seniors at the office of the NDPP.
The accused were free to leave the court and go wherever they want to go. However, this does not mean they were declared innocent. It means the matter was removed from the court schedule due to procedural breakdown. The state might still have the option to re-enroll the case, but for now, the prosecution effort has failed in court on procedural grounds rather than evidentiary ones. So what happens next? Well, immediately after, outside the court, there was widespread attention. As the ruling became known, supporters gathered outside and erupted in celebration. Singing, chanting and dancing filled the area as the accused left the building. Convoys of luxury vehicles arrived to escort them away, and security personnel moved alongside the vehicles as they departed the scene. The contrast between the courtroom seriousness and the outside celebrations could not have been sharper. Inside, contempt findings and procedural collapse. Outside, celebration and public spectacle.
First reaction here from the president of Santaco, Ntate Abner, thank you so much for your time. This is an industry giant. You've been here since day one to support him. Santaco's presence has been here. Your reaction to him now being free, I suppose, and the matter being struck off the roll?
Yes, I'm happy. Life can go on. The law has taken its course. We are happy. There's not much that I can say for now. We have to go back to the drawing board. Remember that Santaco is going for elections. We are so busy. Yeah, so our agenda is full, especially next week. So we are going to engage because one of our own, the chairperson of Taxi Choice, and also the member of the Presidential Consultative Forum, is now free.
If you haven't been following the case, you might be wondering, what is all of this about? Well, it centers around 4 men. Joe Ferrari Sibanyoni, who's a prominent taxi man. Then there's Bafana, King of the Sky Sindane, known for his flashy lifestyle. Then we have Philemon Msiza and Mvimba Daniel Masilela. The state's case alleged that they were involved in extracting money from a mining businessman under claims of protection payments. The defense, however, has repeatedly challenged the framing of those transactions, describing them as business-related disputes rather than criminal conduct.
Completely silent.
But surely this should be concerning, so to speak, to sabotage as well.
Absolutely. From a professional perspective, it's unacceptable. From a collegiality perspective, it's unacceptable. We'll talk in court again. Please excuse me.
Are you optimistic of bail?
My client is waiting. Excuse
Thank you
me.
very much. Of course, that's Advocate Shaun Abrahams. Mr. Abrahams saying that the MPA has been completely silent, not giving them the necessary attention, as well as they continue to walk inside the court.
In affidavits, some accused claim the issue stems from unpaid invoices, joint venture arrangements, and disputed financial obligations linked to quarry and construction projects.
But the complainant is somebody that's been at my client's residence. He's a friend. Everything he's achieved to date, he's achieved because of assistance through my client. He's a person who borrowed money from my client. Precisely. He's a person who borrowed money from our client and, of course, who repaid money. But we will ventilate our issues in court. There's no extortion. There's no money laundering that took place in this matter. We believe these are trumped-up charges.
Now, at the time of the arrest, Joe Sibanyoni's legal team already said that they wanted to institute defamation proceedings against the complainant because this person was allegedly known to Sibanyoni and they had previously done business together.
Particularly having regard to the history of this matter and the relationship that existed between my client and the complainant in this matter. But we'll get behind it. We definitely will get behind it. It's defamatory, and we hold certain instructions to address this defamation. So I have a further brief to address the defamation. So I intend to address the defamation that has been inflicted on my client's good name and good character. My client is a businessman.
This entire situation has attracted significant public attention because Sibanyoni's profile is big and he's also been mentioned in broader discussions around alleged organized crime links and taxi industry influence. His name has also surfaced in hearings at the Mpumalanga Commission, which has examined allegations involving criminal networks and institutional connections. Also, Sibanyoni was allegedly almost killed by Vusi Ketmatala. But none of these discussions constitute findings in any specific cases, and not even this one. Matala himself has not been found guilty of that attempt on Sibanyoni's life. The biggest unanswered question now is whether the state will attempt to reinstate the case. Legally, striking a case off the roll does not permanently close it. It can be re-enrolled if prosecutors choose to proceed, but the credibility and procedural handling of the case will likely come under scrutiny, especially after the current finding. For now, the accused remain free, and the case that once carried serious allegations of multi-million rand extortion has been paused, not by judgment, not by evidence, but by courtroom procedural collapse.
Is this the end of the case? The answer is no, not by a long shot. All the state has to do if they want to reinstate the case, they have to get the express and prior authorization by the National Director of Public Prosecutions. If he gives them the authorization, they will then invite, not arrest, they will then invite the accused persons before the court today to say, on such and such a day, usually on 14 days notice, do present yourself, and then we're back to square one.
What happened in Kwaggafontein was not just about one case. It became a story about court procedure, state readiness, and how quickly a high-profile prosecution can unravel when one critical element fails. And as questions continue to circulate, one thing is for sure. This case is far from over in public debate. Even if for now it is off the court roll, it's definitely not going to be off our lips. So what did you think about how it all played out? Why do you think the state was not ready? And do you think this case should have just been postponed instead of struck off the roll? Let me know your thoughts on that in the comments section, and remember to subscribe to the channel. Also hit that notification bell so that you know when I go live or when I load a video. For now, this case is over. Joe Sibanyoni and his co-accused get to go home to rejoin their families. Maybe they will decide to sue the person who's the accuser in this case. We don't know what will happen. But what I can promise you is that I'll continue to follow the story as it develops. In the meantime, make sure that if you enjoyed this breakdown, you share the video with as many people as you can. For today, that's all we have time for. Thank you for watching, and I'll see you next time.